read a second time, and I call the member for Warringah.
Thank you, Deputy Speaker. I speak in support of the Anti-Discrimination and Human Rights Legislation Amendment Respect at Work Bill 2022. The shocking revelations of the Respect at Work report were deeply alarming to so many Australians. It reflected toxic cultures and systemic failures that have persisted for far too long in Australian workplaces. It's time that this is resolved. I welcome this bill and its endeavours to implement meaningful change. I've previously spoken on the impacts of unacceptable delays once the former government finally began implementing the recommendations of the Respect at Work report, in particular during the last parliament. The previous legislation was a good step, but it failed to legislate enough of the report's recommendation. It's so important that this parliament adequately addresses sexual harassment in the workplace and legislate the remaining recommendations. I again wish to thank all of those people who came forward to share their experiences and insights with the Australian Human Rights Commission. This would not have been an easy thing to do. They should never have had to endure the harassment that they faced. Their courage in coming forward is absolutely making a profound difference. And I would also like to thank the Commissioner, Kate Jenkins, and her staff. This is our opportunity to help extinguish predatory cultures in the workplace and protect Australian workers from sexual harassment and assault. Upon reviewing this legislation, it's clear that this bill seeks to implement improvements that are more consistent with the rights that Australians are entitled to in their workplaces. The right to equality and non-discrimination, the right to freedom of expression, the right to privacy and reputation, the right to the highest attainable standards of physical and mental health, and the right to work. Sexual harassment and lack of enforced accountability threatens all of these rights for Australian workers. That's why we need to change this. This bill addresses the significant issues raised in the Respect at Work report, the release of which corresponded with such high-profile instances and allegations of sexual harassment and assault in workplace, including in this very building. They were incredibly shocking. It led to the March for Justice and a real mobilisation around enough that things needed to change. The bill implements a positive duty which puts the onus on employers to ensure they are fostering safe and inclusive workplaces. However, we need to ensure the legal and regulatory framework is clear and considered. Employees in Australia are diverse, and therefore employers should be able to access clear guidance to best practice. I would ask the government to ensure that the new framework proposed in this bill be widely publicised so that every employer can be on the same page with these important changes. There is heightened cultural focus and justifiable public pressure to implement improvements, and it is our job as elected representatives to set the best example and take lead in securing the vital change. The key impact of this legislation across the proposed 8 schedules, I'm pleased to see some of these positive recommendations, and they include the legislation prohibition of conduct that subjects a person to a hostile work environment on the grounds of sex, the introduction of a positive duty on employers to eliminate unlawful discrimination, including sexual harassment, allowing the Australian Human Rights Commission to conduct inquiries into systemic unlawful discrimination or suspected unlawful discrimination, and extending the period of time between the alleged incident and the lodging of a complaint. When I spoke to the Sex Discrimination and Fair Work Amendment Bill 2021 in the last parliament, I pushed the former government on their hesitation to implement more of the recommendations from the report. So I'm pleased to see this government and this bill continue to pick up what was left out of the previous government's legislation. This bill goes further and is a far stronger approach to tackling the pressing issue. Many are wondering around the employer's responsibility and positive duty. So one of the key changes in this bill, and probably one of the most contentious, is the introduction of a positive duty on employers to ensure workplaces are safe and free from sexual harassment. Sexual harassment is not a women's issue. It is a societal issue. Workplace harassment is not inevitable, it is preventable. This needs to be a collective effort between employers, employees, customers and clients to ensure everyone is being protected from sexual harassment. It is through the fostering of accountability measures and steps to educate each other that this long persistent problem can finally start to be resolved. I'm pleased to see the inclusion of Schedule 2, which pertains to positive duty, as a legal and regulatory framework for an employer's responsibility for keeping their staff safe from harassment. This issue is not only relegated to instances of harassment between colleagues. Employees need to feel safe in their role with customers as well, especially those who work in the service of alcohol industry. Hospitality venues in my electorate generally have a high turnover of young staff who are earning money during night shifts while finding their feet in young adulthood. My office has heard instances of young workers being harassed by intoxicated patrons, sometimes on a regular basis by the same offenders. Asked to leave actions or temporary bans from venues do not solve the root of the problem. I fear there's also an existing perspective that if a patron is a reliable contributor to the fiscal intake of a business, that their behaviour may be dismissed with words like, "He doesn't mean any harm," or "he's just from another time." That misogynistic behaviour, that allowing this conduct to occur, is not acceptable, and it needs to be adequately reprimanded. The safety and well-being of staff must be prioritised by employers. Employers need to be held accountable for how they deal with harassment claims. These claims must always be taken seriously and investigated properly, with meaningful actions taken to prevent it from happening again. This is the positive duty that is lined out in this bill, and failure to act accordingly would see employers held accountable. I know there is always that incredible tension between the fears of an employee complaining of situation, the fear of how that will impact their employment status, especially when it's, the complaint might have serious implications for where they work. And it's so incredibly important that the legislative framework be established to ensure there is a strong protective environment in which complaints can be brought forward. It really is something that should go with the employees' rights, that right to a safe and secure workplace. It's so important, in particular where a worker is experiencing sexual harassment, that they're supported by their employer. And the phrases of, "oh, they don't mean any harm and they're just from another time," are just not good enough. We simply cannot permit or allow sexual harassment conduct to continue or to occur. The excuses are what have maintained this behaviour in the workplace for far too long. It is no excuse to be of another generation or to not really be understanding the complications and what is wrong with this behaviour. Harassment can have significant impacts on a person's health and well-being, and mental health. Aftercare may be needed to work through some of these impacts. And when I attended the March for Justice in the last Parliament on the grounds in front of Parliament, it was quite amazing walking through the crowd of so many women of all ages, all cultural and ethnic background, sharing their stories and talking of events and incidents that had occurred to them, and realising just how common it was and just how much there was a need for change. I note that the Australian Nursery and Midwifery Federation has raised concerns with the lack of definition on what constitutes positive duty guidelines and their lack of enforceability and oversight. So the Australian Nursing and Midwifery Federation have made a submission to the Senate Committee inquiry into the bill, and their submission states that Section 35A of the bill provides the Commission with functions in relation to the positive duty. Those duties include the preparation and publishing of guidelines for complying with the positive duty. However, the guidelines themselves are not enforceable. The ANMF considers that unless these guidelines are enforceable, there will be uncertainty in relation to what constitutes compliance with the positive duty. With a legal background, knowing the litigation process in our courts, I would urge the government to take on board that submission and to ensure the positive duty guidelines are clear for employers. This is an incredibly important framework and a key component to tackling this issue. It's vitally important that there is clarity in what is expected of employers. We cannot afford uncertainty and confusion. We need to ensure it is done properly. One of the key concerns also, and one that will be the focus of a number of amendments in the consideration in detail stage, is the allocation of costs. A cost neutrality approach, as outlined in this bill, will implement a default position whereby each party will be responsible for covering their own legal costs, should a workplace harassment claim be brought before the courts. Now, we know cost is often a serious hurdle to employees bringing forward a complaint. And so I do welcome the changes the bill provides in relation to the allocation of costs, noting though that there is capacity for special cost orders to be made in the event of conduct by a defendant, for example, to unnecessarily extend or have onerous interim applications within proceedings and really cause a complainant to incur unnecessary costs. I know some groups are concerned that this remains a barrier to justice for plaintiffs who simply don't have the resources to fund legal representation and hence are severely disadvantaged in proceedings or mediation, especially against larger businesses or corporations with vastly greater legal resources. I'd like to urge the government to look into this issue, especially when maybe it is a question of legal aid being available in the way it is in the family law system. This idea that each party bear their own cost, very familiar with it from a family law jurisdiction point of view. And I do support it, and I am not in support of some of the amendments being proposed. But I would urge the government to look at this question. We have to have a system where people have access to justice, and cost is not a barrier to being able to defend or to bring forward an action for harassment in the workplace. So I support the approach outlined in the bill, which provides for own cost of each party, so each party bear their own costs, with the judge's discretion that in the event of vexatious claims to overturn own cost rulings, similar to what is provided in the family law system. I believe that does lead to a reasonable balance and progress on the situation at the moment. I would ask the government to consider an amendment that I am intending to move and around inclusive language. This is a strong bill. However, I believe an even more holistic approach is needed in Schedule 8 to ensure improvements are equitable throughout the national workforce. I believe the language currently in place in the Sex Discrimination Act allows employers to make room for instances of exclusion. Our workplaces, and especially younger generations coming through, are diverse and dynamic. LGBTQI+ Australians often have their experiences regarding sexual harassment underreported. Gender association is changing, and we have to recognise that for young people, they don't define by gender norms. They don't want to be defined in that way. But this legislation, I would say, is worded in the old school way. It is still stuck in the past. Schedule 8 seeks to change the wording to substantive equality for men and women. I believe it is an objective of the Sex Discrimination Act to achieve substantive equality for everyone, irrespective of gender or sexual orientation, rather than simply for men and women, as is currently written. So there is a more modern legislation should reflect modern Australia. I will therefore be putting forward a motion to amend this wording to ensure our diverse workforce is protected equally in this bill, but that all generations see themselves and recognise themselves in the bill and the language the government is using. I'm pleased to see the inclusion of the 7 important recommendations of the Respect at Work report in this bill, and I commend the government for putting this on their agenda so early in the term. Sexual harassment is not a women's issue. It is a societal issue. Workplace harassment is not inevitable. Every Australian has the right to feel safe from harassment in their workplace. So I urge the government to think on just the language that is being used, reflect modern Australia, and use inclusive language. Sexual harassment and assault can have severe and lasting impact on a person's self-worth and emotional health. So I look forward to the implementation of this bill and the eradication of harassment and discrimination based on sex in Australia's workplace. And I commend this bill to the House.